With Chapter 4, we begin a new section of the course. So far, we've mostly been talking about the structure of government, federalism, the Constitution, how governments generally function and why. Part 2 talks about civil rights and civil liberties. In different books, you either see these taken together in a single long chapter, or you see civil liberties first, or you see civil rights first. Many times this is a matter of the preference of the author. In our case, I think that civil rights might be a more important current topic that we should focus on. And so that it might be very nice that they start with civil rights. However, as you see, both civil rights and civil liberties will be in this module that we're working on. The book usually starts chapters by asking us important questions that stem from the chapter that we've just begun. And obviously, one of the interesting questions about civil rights, it cuts both ways. First of all, you wonder why exactly or how exactly a country that was founded on the concepts of rights and liberties could have been so slow in actually adopting civil rights for citizens, especially when it comes to minority residents of our country. On the other hand, if we're going to be rational about it, why would you ever not oppress people other than for moral reasons? And so we set for ourselves these moral obligations, and by doing so, I think that it helps us argue across time for why we should have civil rights and civil liberties in this country. Each of us will deal with these questions on their own, in their own consciousness. But I think that what we need to do is give us some tools for understanding the history of civil rights in the United States. So what does a political scientist, or what does somebody who's aware of political science mean when he refers to civil rights? A lot of people use civil rights and civil liberties interchangeably, only basically understanding what civil liberties even are. But you hear an awful lot about things like freedom of speech and freedom of religion and the right to privacy. And the question is, are those actually civil rights at all? And the answer technically is no. What we're really talking about in those cases is we're talking about civil liberties. Civil liberties are protections from the government. When you have a civil liberty, that it means the government cannot stop you from doing something. It does not necessarily mean you're empowered to do it. If you have freedom of speech, it does not actually mean that you are given a television channel to broadcast what you have to say. You still have to find a venue where somebody might possibly listen to you. And it doesn't always protect your absolute freedom to do and say whatever you want. We'll talk about that with civil liberties. When we talk about civil rights, though, we're talking about protections by the government, and that's a little bit different. What exactly do we mean by protections by government power? So if you're not an empowered person, if you're not a person who has wealth or a venue to be heard, oftentimes other people within society are actually able to keep you from having equal rights to political rights, property rights, freedom to do as you would prefer. When we talked about civil rights in America, we were often talking about the right to make contracts that were enforceable. We'll talk about that in a minute. So if you have the right to speak, or the right to your religion, or your even protections from arrest, or in proper interrogations, that still might not mean that you have rights within society to do the things that are necessary to live a happy, and maybe not happy, at least free from intimidation life. So when we talk about civil rights, often we're talking about the right to live free from bondage and intimidation. That would seem to be a bare minimum. To enter into contracts and own property. In a country like the United States, if you are unable to own property, if you're unable to make an agreement that is enforceable on another party, then you have very few rights. You don't have really a right to achieve through work, and you don't have a right to have a place that is yours that other people can infringe on. One of the things that seems to be very dear to most Americans is the right to either own property, or at least to be secure within a rented property. And remember, rental contracts are contracts to have security within some domicile, and that's very important to many people. And to have access to businesses that serve the public. A lot of the civil rights movement was about businesses not treating African Americans as legitimate customers. After all, it's nice to have a home cooked meal, but it's certainly nice to be able to walk out on the town and be respected as somebody who could walk in anywhere and have your money be good for getting what you would like on a particular day. And then finally, educational opportunities. We're always biased towards educational opportunities. It's important for all of you to believe that education is important. And one of the ways that we need to do that, right, is to give equal educational opportunities to everyone. Then your success actually represents your abilities. And I think that that's a rather popular view within American society. So anyway, the concept of civil rights, when we talk about it in the United States, often refers to these. And you'll note that they aren't actually written specifically into the Constitution. So we need to explore how and where these constitutional rights come from. Now we know, if we are students of history at all, that civil rights for minorities has not been an issue that's been important to everyone throughout American history equally. In fact, if you look at the time before the Civil War and you look at issues like slavery, these aren't issues that are described in terms of the rights of African Americans, but rather in terms of what is most effective and convenient for whites within society. The Missouri Compromise is about opening up the West, specifically the Louisiana Purchase, to the creation of new states. And whereas you had an awful lot of people who opposed slavery in the United States, the concept of the Missouri Compromise is that slavery would continue and there would be a boundary to where slavery could be. And so they created a compromise designed to first let Missouri be a slave state, but then afterward the southern boundary of Missouri would become the northern boundary of where future slave states could be created. And that actually seemed to make most people satisfied for the next several decades. By 1850, though, you started to see western states where slavery was either impractical or just not popular amongst the people who had settled those areas, places like California. And California wanted to be a free state. But if California became a free state, even though it was below the Missouri Compromise line, what we would be left with is more free states than slave states. The southern state, remember we talked about the Three-Fifths Compromise, and one of the concepts behind the Three-Fifths Compromise was that they wanted to balance the political power of the free states and the slave states. Well, if California became a free state, then not only would the House of Representatives, because the northern states had grown much faster, be dominated by the northern states and the western states, so too would the Senate. And the southern states were willing to trade that, but they traded it for a powerful fugitive slave law. You might say that the idea of the rights of African Americans ever being equal in the United States might have reached a low point with the Dred Scott v. Sanford case. We talked about that earlier, a very unpopular Supreme Court case where African Americans were said that to never be allowed to be free, even if they had been taken against their will, but probably you would want to be taken to a free state. Well, it's probably not news to anyone that the issue over slavery led to the Civil War. And as such, when the South lost the Civil War, you ended up with a need on the part of the northern states to reconstruct or to revise the way southern states were operated, but at the same time with the eventual goal of bringing them back into the United States on an equal basis. And so a great experiment, I suppose you might say, between 1865 and 1877 was Reconstruction. This effort by the victorious Union to cause southern states to first, hopefully, respect the civil rights of African Americans, but at least to give some power to African Americans. And at first, U.S. government forces, the military, occupied southern states and required southern states to register African Americans to vote. The 13th Amendment, which ended slavery, actually was most of the way passed before the end of the Civil War. In fact, even Tennessee, which had been a Confederate state, chose to adopt the 13th Amendment before the fighting had ended. The 14th Amendment is actually designed to create rules for government protection of certain rights. So when we're going to talk here about civil rights, many of the civil rights and the ability of government to enforce them stem from the 14th Amendment. The 15th Amendment was designed, and it gives you some idea of how unsuccessful Northern efforts to register African Americans as voters had been in the time since the end of the Civil War in 1865. How unsuccessful they had been was that in 1870 they still needed to pass a constitutional amendment to extend the right to vote formally to African Americans. All of this, though, that although these three amendments were passed, although federal troops were in the South, although there was a Freedmen's Bureau, which was actually a effort by the U.S. government for education and training and protection of African Americans in the South. Even though all of this was going on, the Reconstruction and the governments that had been set up for Reconstruction collapsed in the South. And as part of a compromise to allow the Republicans to win the 1876 election, the North was forced to give up on reconstructing the Southern states as places where there would be equality, at least under the law. I point out this Posse Comitatus law that was adopted in 1878 is actually President Hayes's final capitulation on the ability to use soldiers to protect civil rights and to enforce laws in states. And except in cases of insurrection, you might have all heard recently, the president is not allowed to use federal troops in the states. And that's largely because the southern states were able to win that concession after the collapse of Reconstruction. So I said the 14th Amendment was very important for civil rights. And the 14th Amendment introduced a definition of citizenship which included former slaves. When they say that anybody who was born or naturalized a citizen, we often utilize that now to talk about birthright citizenship for people whose parents were born in other countries. However, it was originally designed so that people couldn't use technicalities to say that African Americans weren't citizens. Before the 14th Amendment, citizenship was actually determined, at least in part, by state governments. And the 14th Amendment takes away that power by state governments and says, look, if somebody was born in this country, they're a citizen of this country, and they're subject to the laws of this country, then they are citizens. And so this made it so that you couldn't claim that an African American was not a citizen of the United States, or even a citizen of the state where they reside. We say resident today, but the reason why is that any state in which you reside, you're a citizen of it. And the state doesn't get any say in determining whether you are a citizen of their state, so long as you're a citizen of the United States and you reside in their state. And then what does it do for people who are citizens? Well, it provides a guarantee of due process. The U.S. government is allowed to guarantee that life, liberty, and property cannot be taken from you without due process, and guarantees everyone equal protection under the law. In practice, is that what always occurs? No. But I think you would argue, along with civil liberties, for instance, that just because it says there's freedom of speech doesn't mean there's freedom of speech. Just because it says that there will be no cruel and unusual punishment doesn't mean there is none. But it does give us a legal tool to argue in favor of protections for due process and equal protection. A few years ago, I became interested in a book by Christopher Dawson about progress. And one of the things that Dawson talked about, and that I tended to spend, even though it was a very thin book, I ended up spending many months contemplating, is this myth that we have in society that progress is a steady course, and that we don't have setbacks, and that we don't have periods of rapid advancement followed by other periods where we tend to plateau. And I think anybody who follows economic growth, anybody who follows and anybody who follows any anything across time notes that progress isn't always steady in that area. We don't, just because you say the stock market average is being up 10% a year or whatever across time, doesn't mean that that's true of every year. Similarly, in terms of political and social rights and equality, you do not see a steady growth. Certainly you see that we're in a better place in 2020 than we were in 1850. That's not the same as saying that you can draw a straight line between 1850 and today. And that's how we got to today from 1850. One of the things that you see for certain is that there were more rights for African Americans in 1877, right at the time of the collapse of Reconstruction, than there were in 1900. There's a renewed awareness in American society of exactly where we were in 1900 and sort of the progress that was made in the rights of African Americans between 1900 and 1954. A lot of that was not celebrated through much of my life, but we see some of that. We see movies and such being made of this era in American society that sort of serves as a precursor to the civil rights movement that really began around the time of the Second World War. What we see during the period between 1877 and 1933, though, is a great deal of power of states to pass laws. We call this de jure segregation, or by law segregation. Sometimes we call these Jim Crow laws. Jim Crow was a character in minstrel shows, and so very much this was a statement of anti-African American, anti-black laws in much of the country. I was talking to somebody the other day, and I said, you have to remember that Brown versus Board of Education, that the Board of Education was in Topeka, Kansas, not Atlanta, Georgia. Yes, all of those problems that Brown addressed affected places like Atlanta, Georgia, but not only Atlanta, Georgia. And we see, especially in the late 1800s, early 1900s, that segregation is not just a Southern thing. When we take interest in it in popular culture in the 1950s, perhaps segregation had receded a great deal in northern and western states, but it had been a struggle throughout this period of time, and we see a great decline in civil rights between 1877 and 1933, when society begins to emerge from this. One necessary step for anyone who is seeking to eliminate civil rights, if we're being rational here, and we're saying if you're trying to eliminate civil rights, as many people in the South, white people in the South, were trying to do at the end of Reconstruction and afterward, is that you have to eliminate the right to vote. When people have the right to vote, they tend to vote at least minimally in their own self-interest, but in addition, they tend to vote in a way that will protect them and people like them in their basic political rights. And a lot of the stories about eliminating the franchise is a term for the right to vote that was prevalent in discussions of the rights of African Americans. Later we'll talk about suffrage, which is the right to vote that was popular at the time of women seeking the right to vote in the 19-teens. Well, in any case, if if you eliminate the right to vote, then you're able to eliminate other important political and social rights, because there won't be any voter backlash to doing this. And one of the first, most obvious and seldom mentioned, and I don't even mention it here, the right to vote was largely lost because of terrorism, and both physical terrorism, but mostly economic terrorism against African Americans who chose to vote. If you threaten to take away somebody's job, his property, if you threaten to harm him or his family, quite often the right to vote will seem much less important. But we like to talk about the legal ways, the sort of legal ways in which the right to vote was lost. And probably the most effective of these was the so-called white primary. Remember that for years, the Democrats dominated the South in terms of electoral politics. And by saying that African Americans weren't allowed to be Democrats, you're saying that African Americans weren't allowed to actually win elections. A lot of people will lose interest in taking risks. A lot of people will do very dangerous things in order to secure a positive outcome, but when there is no hope of a positive outcome, the interest in risking your life becomes much less. Also, you see, once you've determined that the Democrats are going to be the whites-only primary, whites-only party, then you have to make sure that they always win. And the way that they did this was to make it very expensive to vote. A poll tax, which was actually cumulative, so if you didn't pay it you couldn't just only vote in the election. You could only pay, if you only had to pay for the elections you wanted to vote in, it would be one thing. But you had to pay for every election, and if you were behind, you wouldn't be allowed to vote. Plus, you weren't allowed to just pay whenever you wanted to. You had to pay in the summer before your crops had come in. And so this was a way that poor farmers were not given the opportunity to vote on an equal basis. And since a bulk of African Americans in the South during the time of the poll tax were poor farmers, this eliminated many African Americans from the voting rolls. Also, property requirements. If you owned your own property, you would be allowed to vote. This was something that was very common in Georgia. It's a good way to keep city dwellers from voting, is that if somebody lives in an apartment, they don't own property, they're not allowed to vote. If somebody is a sharecropper, meaning that they work somebody else's property and then get a share of the profits, they're not allowed to vote. Well, this seriously cut down on the number of people who were allowed to vote. And then literacy tests. Georgia had a literacy test, and there's a lot talked about the unfairness of the literacy test. Even a fairly administered literacy test would have disproportionately harmed African Americans at the time. In fact, of all Southerners, literacy was very low during the early part of the 20th century. There was a grandfather clause. A grandfather clause is a rule that says that if your grandfather was a registered voter in the community, then you would not be subject to the literacy test. Several studies have suggested that the grandfather clause was rarely used because someone would have to admit that whereas their grandfather was a respected member of society, they weren't even able to read. And so what you actually see is a literacy test that was required of African Americans that they either passed or didn't pass, and that white voters, especially white voters who were likely to vote for the Democratic candidate, were just waved through. We focus quite often on tricks to keep African Americans from voting under the literacy test, but what we really see is in the other direction, that white voters who probably should have been failed are just allowed to pass anyway. And all of this did not by any stretch keep every African American from voting, but it did cut down the numbers dramatically. Really high taxes, a tough literacy test, the requirement that you own property, and the assurance that your vote won't really matter anyway is going to discourage an awful lot of voting. Having disenfranchised African American voters, it became particularly easy to pass a series of Jim Crow or segregation laws. These laws were challenged in the late 18th century in a case called Plessy versus Ferguson. Homer Plessy, who I suppose should be a hero of ours, had gotten into a train car and was going to, I believe he was traveling from Illinois to New Orleans. And as it turns out, if you entered a train car in Illinois, they didn't check your race in Arkansas and Missouri. That's not to say that those were not segregated states, but Homer Plessy was able to travel all the way to Louisiana, but when they entered Louisiana, they checked to see whether he was allowed to ride in a train car that was reserved for whites, and they found in his driver's license that he was an African American, and they arrested him. He said that his rights were being violated. He said, "What about the 14th Amendment?" And the Supreme Court said, well, you have political rights, but this is a social right, the right to travel in a train car, and as long as they provided you a different train car for you to travel in, then it's okay. And they created this separate but equal doctrine. Now, the separate but equal doctrine surprisingly was not big news at the time in white America, but became a rallying point for African Americans. And so a lot of times we talk about 1896 as being perhaps a low point in both race relations and racial equality in the United States, where even the U.S. Supreme Court had said it is okay to discriminate against people who have less political and social power. Now, African Americans didn't achieve rights by miracle or by the good nature of white America. Instead, what you see is a rational decision, a complex decision. Black voters were an important part of the New Deal, or the Democratic coalition in the North, in the years following, during the Great Depression. And because Franklin Roosevelt was trying to build a broad coalition to ensure numerous electoral victories and not just to be president for a few years during the Great Depression, he began to depend on and encourage African American voting in the South. Well, the other part of the Democratic coalition were Southern Democrats, and Democrats in the South depended on the disenfranchisement of black voters. And so how do you have a political party that at once depends on Northern black voters and oppresses Southern black voters? Well, African Americans noticed this. people like A. Philip Randolph, who was head of the International Brotherhood of Sleeping Car Porters, said, wait a second, we need to do something here in order to help secure civil rights in the South. Remember, the Pullman Porters, the International Brotherhood of Sleeping Car Porters, were able to travel across the United States, and they would make sure that people, had pillows and such on train cars. But you see that there was a deal of economic power here, because if there was a strike, then it would hurt. It would hurt passenger rail service throughout the country, and they actually negotiated with the Democratic Party. They were the first labor union run by African Americans to be a member of the AFL-CIO. And so we're talking about an important group, in fact, a group that helped organize the March on Washington later on. And this helped give traction and created divisions between Northern and Southern Democrats. Probably the most dramatic change that we have, and a credit to the Democratic Party. In 1948, the Democratic Convention for the first time switched sides on civil rights. Prior to 1948, the Democratic Party was either neutral or against civil rights in the South. In 1948, led by Harry Truman, who had taken over for President Roosevelt, the Democratic Party actually endorsed a pro-civil rights platform plank. This put the Democrats in an awkward position as the party fractured. Some Southern Democrats actually left the Democratic Party and ran against Harry Truman in the 1948 election. Truman won anyway, and so it kind of gave a decisive advantage to anti-discrimination, to pro-civil rights Democrats after that. At the same time, the NAACP had embarked on what was called the litigation strategy. Leading up to Brown versus Board of Education, they had gone around the country bringing lawsuits arguing not against Plessy versus Ferguson, but arguing that you can't have you can't have separate facilities unless they're equal, saying that is exactly what Plessy said, and look, there is no law school for African Americans in this state. They won that case. They said, look, there are no good schools for African Americans in this state. They won that case. Eventually, they reached the point where they said, look, everywhere we go, you claim separate but equal, but separate is never equal, and separate can never be equal. And that was the rationale of Brown versus Board of Education, and they end up winning that case. Followed soon on after that was the passage of the Civil Rights Act of 1957. Remember, there had been Civil Rights Acts passed in the 1870s, and then there hadn't been any more after that. So finally in 1957, they passed the Civil Rights Act, and it's very important because in Brown versus Board of Education, the court had said separate can never be equal. The Department of Justice was given power to investigate all of the different cases where there were claims of separate but equal, and they found that, in fact, that African Americans were discriminated against in many different places. This actually leads to the later Civil Rights Act. So the civil rights movement, as we saw, didn't actually start in the 50s and 60s. It was just more successful. Rosa Parks, we feel like we know a lot about Rosa Parks, this lady who refused to get up when she was asked to move to the back of the bus so that there would be room for a white person to sit in a row that was actually considered, there was a, that she was in the section of the bus that was designated for African Americans, for colored people as the term was used. And that area filled up. A white person got on the bus. They went, and she was required to move out of the seat that she was already in to the back of the bus. Now, this might sound sexist. I find in all of this very vile that any person would ask a woman to get, who was already sitting in a seat, to get up. But I suppose worse than that even is this sense that of entitlement that somebody would have, that they would be able to force people to move from where they are, and frankly, that people couldn't just sit anywhere in a bus that they would want. In fact, in the beginning, there were many efforts to compromise on this. The city of the city wouldn't allow them to compromise, though, and it led to a boycott of all buses in the city until eventually, due to a court case and due to the severe dislocation of the for the bus company, for the city, they were forced to allow people to sit on anywhere they wanted on the buses. Now, I've always thought that Rosa Parks perhaps gets not enough credit for who she was. A person who actually suffered, was vindicated, her side won. In some ways, right, she was doing exactly what Homer Plessy had done, and received a similar treatment. And it's great that she was able to prevail, but the bravery that it would take to actually be forced to, to be arrested for standing up for her principles. And I always feel that it's important that she's not just treated as a nobody who would just happen, oh, here's the name. Probably some of the reason why I took notice of her is because I was living in Michigan at the time that she died. Well, anyway, she's often referred to as a seamstress, but she was also secretary of the Montgomery chapter of the NAACP. So she was aware of what she was doing. She was aware that she was taking a stand against racial injustice. She wasn't just a tired person, as we're often taught in school, right? That's what I was taught. She said her feet hurt. She didn't want to get up. And, she said that, but she also knew what she was doing. She was chosen to be the face of the court case against the boycott because of her widespread respect within the community. But she suffered. I wrote here she lost her job and chose to move to Detroit. But when you consider all of the violence and such, one wonders just what she must have gone through in order to have left a city that she had fought for equality in, and then she moved to Detroit, where she spent the rest of her life. In any case, I don't want somebody like this to be lost to history. So I used to have a photo of A. Philip Randolph here, and I decided that Rosa Parks perhaps receives not enough credit as an individual person for what she did. So what do we see? Actually, we see in the the mid 1960s, right? This is exactly the mid 1960s. Probably the biggest step forward in terms of laws passed on the federal level to protect the desegregation and equal rights. The Civil Rights Act of 1964 finally gives the Department of Justice the power to bring lawsuits against southern states and against communities that discriminate against people on the basis of race. And they were given power to both investigate and to bring cases. And there was a requirement that if a community were to seek government funding for anything, particularly you see education funding was very important at the time, that they had to be certified as not discriminating against. You'll see in a lot of communities, high schools were built in the 1960s that were the first desegregated high schools in that community's history. And so at a time when there was a lot of federal government spending, it became necessary for many states to determine whether they were more racist or whether they were more in need of government help. And you see a big advancement. You see a negative reaction in the South to the Civil Rights Act of 1964, and you see the Democratic Party suffering in the South, even as they won nationwide. They suffered in the South for having made this decision. Basically, in about 20 years, the South went from being a reliably Democratic part of the country in presidential elections to being one that the Democrats rarely win in the South anymore. The Voting Rights Act in 1965 was passed in order to level the playing field in terms of voting. So even after you get rid of rules like laws against the poll tax and the literacy test and so on, you still have very few people who are registered to vote, very few minorities who are registered to vote in the South. And so what happens is the way you turn that around is by allowing people, federal government employees to register people to vote. We do see a loss of momentum in many cases for civil rights for African Americans after this, starting in the 1970s. We see that this gap between social and economic equality and the importance of it, as seen by many people in the United States, and political equality. We see a gap between the government support for ending de facto or in practice segregation versus ending by law or de jure segregation. And you see that affirmative action was particularly unpopular in many communities. Particularly you see in a lot of northern states where there had been a sense of the importance of political equality, that when it came time to seeking economic inequality, there was much less support for this. You see a process of court cases throughout the 1970s that seek that seek a promotion of economic and social equality, and then you see judges start to give up on this process during the 1980s. So my fascination for civil rights for African Americans shouldn't cause us to lose sight that civil rights has been a struggle for many other groups in American society. I list some here: women's rights, gay rights, immigrants, and the disabled. And entire books, entire courses can be taught on all of these issues. When we talk about equal rights for women, we really have two stages here. In large measure, what we see is the struggle for voting rights, term suffrage, that's largely achieved by the 19th Amendment in 1920. You see that women had been gaining the right to vote on a state-by-state basis long before the adoption of the 20th Amendment. I'm sorry, the 19th Amendment in 1920. But you don't see this extend into the areas of other forms of non-discrimination. And what you actually see as the catalyst for non-discrimination laws is first the end of the, first the World War II and the economic disruptions that happened because of this, and more women entering the workforce in non-farm capacities. And you also see an effort for equal rights by women during the 1960s and 70s, trying to enter the workforce and obtain more successful careers. Although the Equal Rights Amendment failed, equality advanced primarily through law and court action during this time. Ruth Bader Ginsburg, who's now on the U.S. Supreme Court, I could have had her picture here too. We'll have her picture when we talk about the Supreme Court, was a leader in this movement during the 1970s and 80s for women's equality. Gay rights, or the rights of people who wish to be in relationships with people of the same sex, is really a evolving process in the law up through just a few years ago. What we see in many cases is greater and greater widespread acceptance within society, but also we see, until not very long ago, within my lifetime, within the lifetime of your parents, we actually saw laws against sexual relations among same-sex couples, so-called sodomy laws, that were enforced in the United States, including in Georgia. We saw laws against marriage, so-called DOMA, or Defense of Marriage Act laws, that were being passed in the early part of the 21st century. We see limitations on adoption, property transfer, and the ability to discriminate in hiring that also extended well into this time. Interestingly enough, full protections of same-sex relationships, marriages, didn't really become part of the law until 2015. Obergefell versus Hodges is an interesting Supreme Court case. I'm so old that I was already this old when it happened, but you know, you're so old that you were already alive when it happened as well. So we have our photo here of Jim Obergefell, who, again, I don't know that he is really seen as the hero that he is, but he is responsible for a lot of the legal conflict and ultimate success of the same-sex marriage movement in court. And it is fair to say that by the time Obergefell won his case in 2015, same-sex marriage was already legal in 36 states. However, you know, if the case went to the Supreme Court, it was because somebody was still seeking to deny civil rights. And Sadly, Obergefell's case doesn't actually involve a happily ever after. Obergefell, um, his spouse John Arthur, who he had been caring for several years, as Arthur actually had ALS. We used to say Lou Gehrig's disease. They were legally married in Maryland, but when Arthur died, Obergefell wasn't able in all states and with the U.S. government to be treated as a surviving spouse. So a lot of what the case was about was to gain a nationwide recognition that they had been married and that they had the right to marry and that he had the right to be treated as a widower, which he was. But you would have liked to see, and if you were to have made a Hollywood movie about it, they would have won and been able to enjoy the aftermath, right? But no, and you see in this a great deal of the practicality of same-sex marriage, as you have cohabitating partners seeking the legal benefits of marriage.